Today, the former governor of Migori, Obado, was coming to court for the probation officer to bring out a report. In the pre-sentence report, the family of Sharon, the late, is asking for compensation. They are asking for the house that Obado had promised to Sharon. They are asking for the car that they were using. They are asking that Obado to continue providing for the three children of the late Sharon. They are also asking for compensation. They are saying that to sell their land, they are to sell their cow, so that they meet the costs of traveling to Nairobi for 8 years for this case, and very many others. The report comes out saying there have been discussions going on, and they are not aggrieved. Obado, according to them, they have no problem Obado given a non-custodial sentence. A non-custodial sentence is a sentence when you serve outside. You don't go to prison. You remain outside, but you serve a probation sentence called community service order. So the question every Kenyan is asking, Bramwell and Vivian tells me, Court Helicopter website and emails, everybody is asking, can Court Helicopter confirm whether a criminal court has jurisdiction to order for compensation? Yes, this court, the High Court Criminal Court, today we have come to the High Court Criminal Court. Obado will be sentenced in September from this court. Does this court have the power to order for compensation? Yes, this is not the first time this matter has gone to the courts, and the courts have said that. We are dealing with the criminal revision number E047 of 2021, where Ian Ocheng Owaga, the applicant, versus the Republic. In this matter, this is an appeal that went to the High Court at Nairobi, and this is the decision of the same judge, Justice C.W. Githua, where Obado is going to face sentence. What did Justice Githua in this case in 2021 pronounce herself on? What are the facts of this matter? This person was convicted and ordered to pay a fine of 100,000 shillings and to compensate the complainant with 850,000 shillings. This was a magistrate who ordered this. This man was mad and said, how can you tell me I pay a fine of 100,000 shillings and I compensate with 850? This matter went before the judge. The argument was that a criminal court has no jurisdiction to order for compensation. Let us go to this. Paragraph 12. In my view, only two issues arise for my determination in this application. That is, whether the learned trial magistrate had jurisdiction to make an order for compensation in favor of the complainant, in addition to the sentence imposed to him. Can the court order a sentence? Can Obado be sentenced to death or to life or to 30 years and still be told to compensate? Paragraph 14, Justice Githua says, paragraph 15, turning to the issue whether the learned trial magistrate erred in making an order for compensation in count 1, I'm unable to agree with the applicant's submission that the trial court lacked jurisdiction to make such an order and that orders for compensation can only be made in civil suits. I say so because Section 31 of the Penal Code expressly allows courts to order compensation in criminal cases in addition to or in substitution to of any other sentence. For the avoidance of doubt, Section 31 of the Penal Code provides like this: any person who is convicted of an offense may be adjudged to make a compensation to any person injured by his offense, and the compensation may be either in addition to or in substitution for any other punishment. This is Section 31. The judge is saying the criminal court, this court, can order for a fine, it can also order for compensation, and it can also make a very serious decision that they can substitute the punishment with compensation. The judge, Justice Githua, in paragraph 16 says, as I held in a Francis Gishugu Njuguna and Republic, that is a decision also by Justice Githua, which has been cited by the applicant. Section 31 of the Penal Code must be read together with Section 175(2)(b) of the Criminal Procedure Code, which also provides for circumstances in which compensation can be ordered in criminal proceedings. The provision states as follows: B. Finds on the facts proven in the case that the convicted person has, by virtue of the act constituting the offense, a civil liability to the complainant or another person, in other case referred to in this section as the injured party, the court may order the convicted person to pay to the injured party such sum as it considers could justly be recovered as damages in civil proceedings brought by the injured party against the convicted person in respect of the civil liability concerned. What did Justice Githua conclude? From the foregoing, therefore, I make the following orders. The judge ordered this person, in order for payment of compensation to the complainant in the sum of Kenya shillings 850,000 is hereby upheld, but the default sentence is set aside. The judge, Justice Githua, ordered this person to pay the fine of 100,000 shillings plus compensation of 850,000 shillings. This is the decision by Justice Githua in 2021. The same judge is making a similar decision in Obado's case. Has the Chief Justice, Martha Koome, ever gave compensation in a criminal matter when she was a judge? Yes. In the High Court at Kenya at Nakuru, Civil Appeal number 90 of 2001. This is David Gashiri Gatheru, the plaintiff, versus MWWM, the defendant. This was a case where somebody had carnal knowledge by force. He raped somebody and infected that person with a sexual offense, sexual disease. What did the judge say? This is Justice Martha Koome. Rape is traumatizing experience. Indeed, in these days of AIDS, one can only hope that the plaintiff was not infected with the same. I did not say more regarding the above statement. Suffice it to say that I'm satisfied that the learned trial magistrate perfectly assessed the sum of Kenya shillings 200,000 as general damages. This is Justice Martha Koome on the 24th of March 2006 when she was a judge of the High Court. She gave compensation of 200,000 shillings for somebody who infected somebody with a sexually transmitted disease. What about the judge of the Court of Appeal, Justice A. Abida Ali Aroni, in July 11, 11th of 2022. This time, Justice Aroni was sitting in Garissa as a judge in case number E010 of 2021. This is between the Republic and Kalimoe Shale Ahmed. What was the issue in this matter? The person was convicted for the offense, and the judge went ahead and said, therefore, the accused is convicted for a term of 20 years for the offense of rape and 2 years for the second offense of wrongful distribution of obscene or intimidating images. As for damages, the accused will personally compensate the victim a sum of Kenya shillings 500,000 shillings for the pain and suffering and the damage to her dignity. This is Justice Abida Aroni on the 11th day of July 2022. This is not the only authority Court Helicopter Bramwell and Vivian went to look for. Compensation also in Geoffrey Mwangi Murungi and another. This is Justice D.O. Chepkonyi on December 20th of 2022 versus the Republic. What? This is case number E108 of 2021. Justice Chepkonyi, Dora Chepkonyi, said, in conclusion, I sentence this person with a fine of Kenya shillings 200,000 and also compensation of 6,322,790 as compensation. Still, Vivian had to rush to look for in a child pornography matter, where in a child pornography matter, this one is a sexual offences case, E007 of 2027, J.C. Kibosia, PM. This is a magistrate's court. Republic versus Sharon, this child, the accused was Sharon Nanjala, Wabule Elias, Roshamvangasana, Cherop. The magistrate. This is a magistrate's court. The magistrate ordered with this, the victim, this is the restitution. The victim was ordered a restitution order pursuant to section 26 of the Victims Impact Assessment Act. He was ordered to pay restitution amount of 2 million shillings to this minor. Can you imagine? This is restitution. What are we learning from in this matter, the last one, which is very, very sad? This is in the High Court of Kenya at Embu. The criminal case number 31 of 2007. LCWM, the plaintiff, versus the Honorable Attorney General. This is a story where a person was raped, not using a human organ, but a bottle. Can you imagine how people can be barbaric? A gang rape, men holding a woman and using a bottle of beer to insert that bottle into the private parts of a woman. It is bad. Bramwell and Vivian had to convince me to bring this to the public. It was bad. This is beastly. The judge says the act of penetration with a bottle actually amounted to rape. This was a gang rape, given that the perpetrators were several. It amounts to an offense under Section 10 of the Sexual Offences Act and punishable to the term of not less than 15 years imprisonment to life. Therefore, make torture aggravated. The judge gave a general damage to the tune of 5 million shillings and aggravated damages of 2 million shillings. The judge computed this way: special damages 122,915, general damages 5 million, aggravated damages 2 million, total 7,122,915 cents. Interest on the above at court rates. This is a judgment of Justice W. Karanja, judge. That time, judge was on the 29th of September 2010. You have seen the plethora of authorities that Court Helicopter has brought you. Section 31 of the Penal Code, Section 175 of the Criminal Procedure Code provide for compensation. This criminal court has power to order compensation. Section 26 of the Victims Act, Section 26 provides for restitution. Justice Githua has done it. Does the argument of the Obado family succeed? Yes. Obado provided food and shelter to the family of Sharon. Obado, number 2, took up the children of Sharon, free of them, fed them, educated them, clothed them, treated them. Therefore, he had acquired parental responsibility. And what is the best interest of the minors? The minors must get school fees, the minors must go to school, the minors must eat. The third issue that comes in, has Obado the resources to do that? Yes, he has the resources to do that. But mischievously, my crew, Bramwell, asked me this question. Will this now substitute the sentence? And this is Bramwell. I told it, this is quite mischievous. Bramwell, how can you raise this issue? Bramwell told me as he was walking from court, people were asking him, does this mean Obado is going to buy freedom so that he pays and he walks out free? No. The answer is simple. The sentence will be imposed. On top of the sentence that the judge will give, she has the power to order for compensation. On top of the power of sentencing and compensation, the judge has power to order for restitution. All these three can go concurrently. But it's a big challenge. This is a landmark question that the judge is going to give. So only Court Helicopter can bring you the true position of the law. We thank our crew, Vivian and Bramwell, for doing the research within a very short time. We will not reproduce the probation officer's report because that is a document for the court and the matter is before the court. Keep watching as we bring you the law as it is. Wakili Dan Sanomari from Milimani High Court, Criminal Court, #1. Asante.